Circuit Court for the County of Kent is now in session. Honorable J. Joseph Razzi presiding. We are here in the case of Francine Seals versus National Interstate Insurance Company of Hawaii. Case number 23-11345NF. This hearing is being recorded on Zoom and live streamed on YouTube.
And the matter is before the court today on plaintiff's motion for partial summary disposition pursuant to MCR 2.116C10 and attorney fees under the no-fault statute. So as an initial matter, counsel, would you please place your appearances on the record?
Thank you, Your Honor. Aaron Wisely appearing on the behalf of plaintiff Francine Seals.
Thank you.
Mark Wright Sr. appearing on behalf of defendant National Interstate Insurance Company of Hawaii.
Very good. Thank you, Mr. Wright. And a couple of the preliminary matters before we jump into the substantive part of the motion. There were evidentiary issues raised regarding a couple issues, and I wanted to get a sense. The first one was, Mr. Wright, kind of in passing in the brief, you mentioned spoliation of the evidence by disposal of the body here, which I assume was cremated or some such that prevented an autopsy. Well, what happened to the body that you couldn't conduct a kind of counter autopsy?
As far as I know, Mr. Seals was buried, and that's it. By the time the suit was filed, I think it had been almost a year after his death.
So you could have dug him up, but you elected not to.
Well, I didn't know how much value digging it up might have been.
No, you never know until you dig it up. And I say that from firsthand knowledge, having dug up at least one plaintiff in my work history. So, not personally, I'll note it was done by others. All right, Mr. Wisely, response on spoliation.
The response on spoliation would be, first of all, I when I saw the footnote reference not once but twice, there was never. First of all, there was an autopsy performed by the only person who was allowed to perform an autopsy. The issue has never been raised during the pendency of this litigation until in the footnote in defendant's response. And my response to that would be that at the time Mr. Seals was buried and his remains disposed of, there was no reasonable expectation of any litigation at that point. Mrs. Seals' survivor's loss claim was not even opened by the defendant until 2.5 months post-accident. They never requested that the body be preserved at any point. That footnote in the response is the first mention ever of a claimed spoliation issue.
Your Honor, if I may respond.
Yep, go ahead.
Yeah, I put that in the footnote to essentially circumvent any argument that plaintiff might make at some later date, saying that, well, we never, Dr. Kaplan, for example, did not, inspect the body. And it's essentially saying that, kind of preserving that issue if it were to come up.
Sure. Well, and I will state for the record, I did have a case involving a med mal death where I did dig up the person a year after. As I was at the U.S. Attorney's Office defending one of our rural health clinics, and then had I did have a medical examiner, my contractor, my expert employee, perform an autopsy. So to learn what we could, or at least exclude what I thought was a potential cause of death. So it can be done. Since it wasn't asked for here, I think the spoliation, it would ring a lot more true if you dug her up or dug him up and, deterioration or whatever had made it impossible to make the determinations. And, sometimes they are and sometimes they aren't. So, ours was, in our case, we couldn't make that determination, and it was a good solid year later. And I recall talking to that pathologist, and I said, well, what could be, kind of the worst case scenario where you can't do the autopsy? And she said, oh, if they're soaked in water, that's the worst. And the day of it, I called and I said, well, was there water? And she said, oh yeah, totally immersed in water. But she still managed to do the autopsy, which I can't even begin to imagine how disgusting it was, and reaffirmed my belief that I made the right choice by going to law school instead of medical school. So I'm going to deny, any sanction or discovery remedy on spoliation at the time, because I do believe, you'd have to pursue that autopsy further than simply saying, well, they're put in the ground, I couldn't do it. Sometimes you can, it all depends what you're looking for. So the second issue I did want to raise here, and this is raised in the reply brief by Mr. Wisely, is the question of evident in the admissibility of their pathology report, which was obviously done without an autopsy. It was just a records review. And then second, the EMT report. Mr. Wisely says, well, Judge, in order to respond under the C-10 standard, they need to present admissible evidence. And their response is replete with references to both those items, but neither are admissible. Mr. Ray, what's your argument that they are?
Yeah, Your Honor, in the case of Bernard Manufacturing versus Gates, which is at 285 NIS 362, 2009, page 373, the Michigan Court of Appeals wrote that in ruling on a motion for summary disposition, the trial court could only consider substantively admissible evidence. However, although the evidence must be substantively admissible, it does not have to be admissible in form. There only needs to be a plausible basis for the evidence to be admitted. Dr. Kaplan's CV indicates that he's more than qualified to provide the opinions regarding the cause of Mr. Seal's death. Thus, while his CV report, his CV and his report may not be in admissible form, they're certainly plausibly admissible with the appropriate foundation.
Okay, so in other words, you've provided sufficient evidence of that admissibility at trial, and thus I can consider it. What about the EMTs? Have we taken depths, or is there any sworn testimony or affidavits that validate what the EMTs say in that report?
That falls under the same category, same thing.
Okay, all right. So in other words, we can anticipate, as we do with most professional witnesses, that they're going to testify consistent with their report, even though the report itself may be inadmissible. All right, let me bounce to Mr. Wisely.
Sure, Your Honor. Let me take the EMTs first. The issue with the EMTs is there are arguments raised in the response by the defendants that the EMTs pronounced Mr. Seal's cause of death as cardiac arrest. It's a misnomer for a couple of reasons. Number one, they're EMTs. There was no foundation as to their qualifications. And as we all know, only certain specific qualified individuals in Michigan can pronounce cause of death.
It's always got to be a doctor, right? I mean, no EMT anywhere should be pronouncing death.
Correct. And what they actually reference in their EMS run report, as you'll note, they never pronounce cause of death. They simply say cardiac arrest. And I will say this in the last 3.5 months, I've been taking an outdoor emergency care class to join the National Ski Patrol. So I've learned a lot of initial responder type information. Cardiac arrest is simply the lack of a pulse. That is what cardiac arrest is. And actually, Dr. Donahue explained that in response to some of Mr. Wright's questioning during Dr. Donahue's deposition. That's attached as an exhibit to actually both of our briefs, where Mr. Wright is asking him concerning Mr. Seal's having a cardiac arrest, and would you put that as a cause of death? And this is at page 9 of Dr. Donahue's deposition. He says, answer, a cardiac arrest, that would go on every death certificate because you can't have death without cardiac arrest. It's a meaningless term. Next question, so cardiac arrest is a meaningless term? Answer, yes. Question, I guess I don't understand. Answer, it's a meaningless term for the cause of death. Everybody who dies has a cardiac arrest. When we're dead, everyone will have experienced a cardiac arrest, which means the lack of a pulse. That's it.
Okay. Okay.
It's a finding. It's not a determination as to a cause of death. With regard to Dr. Donahue, or excuse me, Dr. Kaplan, I don't believe any foundation for his opinions has been laid. We have a report that was apparently sent to a third-party vendor who then sent it to a workers' compensation attorney. Note that the report is not directed, or the cover letter is not directed to Mr. Wright. It's directed to the comp attorney that handled the defense in the collateral matter. When I see that, there is no foundation for it. And because for me, without any type of support, whether it's an affidavit submitted by Dr. Kaplan outlining his credentials and verifying the findings that he apparently includes in that report, it's unsubstantiated at this point. It is hearsay. There's no foundation for it. We also have a curriculum vitae that was attached for Dr. Kaplan, or apparently of Dr. Kaplan. I assume it's accurate. The licensure for him to practice medicine in the state of Michigan, which to me would seem to be a prerequisite to offer an expert opinion, isn't up to date. His own curriculum vitae says his medical license in Michigan was through 2023. So on those grounds, we're here at the summary disposition phase. Discovery's done. Case evaluations coming up in a couple of weeks. This is, filing your dispositive motion and responding with as required by the court rules. For a euphemistic term, it's put up or shut up time. And at this point, all we have is a lack of foundation for anything as to what Dr. Kaplan's opinions may be. And also when we take into account that it is, assuming it's accurate, is an application of his analysis to a workers' compensation statutory definition, which this case is not. It's a different definition.
Sure. No, and certainly arguably some of that would go to, weight rather than admissibility. However, at this juncture, yeah, and I mean, well, let me hear Mr. Wright's response on the admissibility licensure of Dr. Kaplan question.
Dr. Kaplan is currently the medical examiner in the state of New York. And so he's licensed there. There's no requirement that he be licensed here in Michigan at all. The question is whether or not he possesses the requisite knowledge, expertise, and training, which is CV adequately states, to provide the opinions that he is providing. So
if it was a malpractice case, he would have to be licensed in the same specialty, but we're not there yet. He is the medical examiner, thus, kind of the counterpoint to the local ME's point. So, I mean, we do have kind of apples for apples, and you're saying the licensure, in-state licensure, is unimportant in that regard.
Yes, and when he conducted his examination and made his report, he at the time had his Michigan license because his report is authored October 27, 2023, which Mr. Wisely clearly indicated in his court moments ago that his license was valid in 2023.
Okay, all right. So he wrote the report, it was valid, and it doesn't really matter if his license is lapsed. Presumably, we could bring him into court and swear him in, and he could testify and qualify as an expert in Michigan. Under that, and I guess what I'm hearing from you is, I guess, and I'm comparing it, and of course, in a medical malpractice case, you have to file an affidavit of merit or something of that nature, laying out those facts and having the doc take the additional step of swearing to those in an affidavit. That's not required in a civil no-fault matter like this one. You just need form of evidence that I can reasonably assume would be admissible at the time of trial, of course, subject to its admissibility. And if Mr. Wisely wants to attack that at trial, that obviously is his prerogative. So that's what I'm understanding your argument to be.
Yes, it is. And also, just one other point. National Interstate Insurance Company of Hawaii, my client, is the also the workers' compensation insurer. And so I don't see that being a distinction as to whether or not it was
As to the medical
in the
conclusions, it
case of
certainly
this case.
might, yeah, impact his legal standard, because I frankly have no idea what the comp standard is and no desire to learn it. But having avoided comp all these years, why would I want to do it now? So yeah. Okay. No, I think I understand what you're saying. Any final word on it, Mr. Wisely, on admissibility?
Sure, Your Honor, and this goes again to the, I guess, the lack of foundation, which brings this statement by or report by Dr. Kaplan even into further question as to whether it should even be considered. Is Mr. Wright just said Dr. Kaplan is a forensic pathologist and coroner in New York, if I heard him correctly.
That's what I heard. Yeah.
Okay. And at the top of Exhibit L, it says he's apparently the deputy coroner in Ohio on his curriculum vitae, where it goes through work experience, academic appointments, administrative appointments, clinical appointments.
Well, maybe he's in one of those jurisdictions that borders New York and Ohio. I don't know. Any thoughts on that, Mr. Wright? Doesn't matter.
My point is, Your Honor, if I could just finish, is none of this work experience references any current employment as a medical examiner in the state of New York. Again, that kind of buttresses my point that, this is not in a form or substance that the court should consider on a dispositive motion.
Okay. All right. Well, go ahead, Mr. Wright.
Yeah, no, I was just going to say, can we have a CV that's up to date, up to the minute? Absolutely not. It can't be done. All right. And so the fact that he ended up moving recently to the state of New York, I don't see what the consequence is in either case. And I'm unaware of any law court rule that says that he must reside in the state of Michigan, for example. We can have experts outside of state. It's done all the time, especially in malpractice cases, as I'm aware.
And of course, he hasn't been deposed yet, I take it, Mr. Wright.
No, he is not.
All of those items fair game for deposition, and for that matter, future motion practice, I think, by Mr. Wisely as to admissibility, both of him as an expert witness and his conclusions that he makes in his report. Well, for purposes of today's hearing, I will rule that very commonly in cases that involve medical evidence, the court receives reports. Those are mandated under the federal rules, and of course, commonly created under the Michigan rules as well, though not mandated by experts. Here, I do have a report that's been submitted, and the basis when an attorney submits that as the findings of the expert, well, they know darn well if the expert contradicts that report or testifies inconsistent with it, then that's going to be a problem for the finder of fact at trial. So, the report does have significant weight, even though in its form as a report, it would not normally be admissible in evidence, only the testimony. But for that matter, neither normally is the discovery deposition of the physician admissible in evidence, even though routinely, I take testimony from such depositions as relevant at summary disposition like we are today. So on this one, I'll agree with Mr. Wright and allow those items, subject, of course, to all evidentiary objections prior to trial. But for my consideration today, I will allow those items to be considered in their present form, even though they may not be admissible at trial. And that will be both the EMT report and the doctor's report. Again, I think it's a fair assumption that the folks will testify consistent with what they wrote in the report. Certainly, a fair assumption that in the case of the EMTs, right, they can't pronounce death. They did have to do that, and maybe they can get a time of death, but I'm not sure that the EMTs even can do a cause of death. I think they normally just simply pronounce death for purposes of discontinuing life-saving measures, and then later the medical examiner fills in the cause of death, as appears to have happened in this case. So I'm going to deny both those matters, and I'll consider this submissions of the parties and move on to the substance of the briefing at this point. Mr. Wisely, this is yours. And I mean, just, if I elevate my aircraft to the 10,000 foot level and look down at this, I say, well, all right, we have a guy who was arguably here, as I think defendant's expert says, a walking heart attack anyway. He gets in a truck crash and has some indicia, perhaps, that there was a heart attack connected to that, immediately preceding. In the truck crash, it appears that he sustains additional injuries, somewhere in the truck crash, and it's sequela of, after all, he's entrapped in the cab, so there was significant impact. There is all the effort to get him out and to see if there can be any life-saving attempts there, including the actions by the passenger. And I've got two different medical opinions. Why isn't this just clearly a fact issue that I punt through the uprights and send the matter to trial?
Well, now that you've decided to accept Dr. Kaplan's report for the purposes of the response, I'd be hard to argue against you, Your Honor. But
okay, yeah, do it anyway.
But exactly,
that's never stopped you in the past, Mr. Wise.
This is why they pay us the big bucks. I'm not giving up without a fight. While that may create a triable issue of fact with regard to, was this an accidental bodily death? I would take into account a couple of things for Your Honor's consideration. This statement, comment, admission by the defendant in their response kind of applies equally to both grounds for relief that I was requesting today. And that's on page 13, where they say the death certificate is presumptively correct. Okay. So me coming forward as the moving party, I have now met my burden based on that admission alone.
You've got a prima facie case. Right.
I got it. Exactly.
So you shouldn't be kicked out on summary disposition, and I don't see a motion from Mr. Raitt for summary disposition. So, right. All right, here we are. But I think Mr. Raitt says, well, that's where it ends. However, at that point, everyone knows you can challenge the determination.
Here's the thing, and why summary disposition, and in my opinion, is still warranted, because Dr. Kaplan's findings were in fact rebutted and addressed by Dr. Donahue in his deposition. In particular, let's talk about the amount of blood loss. All right, Dr. Donahue, the doctor who did the autopsy, finds 500 milliliters of blood in the peritoneal cavity of Mr. Seals. You have Dr. Kaplan, who says 2,000 is, usually required. If you note in the analysis of Dr. Kaplan, he does not apply that amount of blood loss to Mr. Seals, specifically in the physical condition he was at the time of the accident. Dr. Donahue did, in point blank, in response to questions from me as well as Mr. Wright. And, given the 500 milliliters of blood loss, was that sufficient to cause Ron Seals' death? And Dr. Donahue said unequivocally, yes, especially when it's taking into account those pre-existing conditions, those comorbidities. Like you said, Mr. Seals may or may not have been a walking heart attack. Doesn't change the fact that when he hit the trees, in Dr. Donahue's opinion, that caused the lacerations to the liver, that caused sufficient blood loss, given Mr. Seals in the condition he was, to result in his death. Dr. Kaplan does not address that specific finding either in his report. Dr. Donahue had was given the opportunity to be confronted with those findings or apparently contrary findings by Dr. Kaplan, and disagreed with them and applied them specifically to Mr. Seals.
Well, I mean, Kaplan knows about the comorbidities, presumably, when he's writing. So, his report can be taken as saying, even with those comorbidities, that amount of bleeding is, in his, expert autopsy opinion, not enough to be, a cause of death. So, I mean, I'm gonna, presume he's got, that same universe of information, including reading Donahue's report going in.
All right. And maybe that is an issue of fact for you. I don't see it being refuted or addressed at all in the opinion of Dr. Kaplan. So I'm still sticking with the actual person who is authorized to pronounce Mr. Seals' cause of death, the death certificate, as well as the testimony of Dr. Donahue. So I'm not dumb. I can read the tea leaves, Your Honor. I get where you're going. But let me go back to that comment and that admission in the defendant's brief concerning the death certificate being presumptively correct. That also applies with equal force to the request for attorney's fees concerning whether or not this was or was not a reasonable denial. Remember, and I hope the court picked up on it, as well as Ms. Partridge. In my motion, I put the denial date as August 31 of 23. I didn't have Mr. Cherney's dep transcript available at that time. He did correct himself at his deposition, said it's September 21. Okay. So the denial date, the official formal denial of benefits, was made by Mr. Cherney on September 21, 2023. Under the attorney fee standard, was the insurer's denial reasonable at the time the denial was made? Dr. Kaplan's report is dated October 27, almost 5 weeks after the formal denial of my client's claim. So when it comes to assessing whether or not Mr. Cherney acted reasonably or unreasonably, which in my opinion he did, for basis of determining attorney's fees, Kaplan's report's irrelevant. It was not a factor. So what we have is...
And Cherney, the adjuster, didn't testify that he called up the doc and got kind of a prelim, verbal report or something like that. Okay.
No. So we go back to a presumptively correct cause of death based on the death certificate. And then when you take that add that onto the other information Mr. Cherney claims he based his denial on. And remember, Mr. Cherney says, I'm not a doctor and I did not deny this claim based on medical decision-making. So all he has is a police report, EMS records, death certificate, the video, the autopsy, everything of which says Mr. Seals died of accidental bodily injury sustained in the accident.
Well, except the EMS report, right? I mean, that comes to what you argue, and I'm sure will continue to argue, is the incorrect conclusion. The cause of death was the cardiac arrest.
And Mr. Cherney did not say that he determined cause of death based on the EMS report. Remember, Mr. Cherney's answers to interrogatories were, I looked at the video and determined he was dead when he was still on the road.
Yeah, he gave a lot of weight to the video.
Oh, yeah. Not a lot of weight, Your Honor, almost exclusively. He flat out says in his answers to interrogatories that He determined Mr. Seals was dead when he slumped forward in the video, not at any time after.
And you're saying, because I mean, his status as a layperson kind of cuts both ways in that instance. Obviously, and he knows full well he's not qualified to make any diagnosis. However, or is a reasonable expectation for a lay insurance adjuster to say, whoa, that guy looks like he had a heart attack and died right there on the camera. I mean, and base his denial on that. Is that enough? I mean, to meet the reasonableness standard.
I think that is the definition of an unreasonable, especially when you have the other information that Mr. Cherney had. So he says, okay, Mr. Seals is dead when he leans forward before the truck runs off the highway. Okay, that is his theory.
His starting point. Okay.
That's his story, and he's sticking to it. At his deposition, when I asked him, you had the police report, right? Yep, had it. You have signs of response to stimuli when Ms. Grant rubs him on the sternum. We have, Mr. Cherney says, yep, we have the Trooper Knowles report. Again, going back to my OEC training, one of the things when you arrive at an unresponsive patient, first thing you do is you check airway and breathing. And you also check circulation. You check for a pulse.
Pulse, yeah.
Yeah.
I remember that too.
Trooper Knowles it has positive responses to both. So Mr. Cherney, even though having 3 distinct signs of life after when Mr. Cherney kills Mr. Seals, he's sticking to that story. You get to sit as the finder of fact and determiner, and make the determinations of law and the attorney's fees. And given that those facts, as of the date of the formal denial, are never going to change, I think you've got enough to rule as a matter of law based on these facts that Mr. Cherney's denial was unreasonable. In my opinion, there is no rational basis for this particular insurance company to have denied the claim on September 21.
And you're basing that on not that every single fact said, but that a insurmountably large amount of facts pointed towards that, and there has to be some unreasonable or self-serving basis. Is this adjuster? Is he in-house or is he an independent adjuster?
He's in-house. And I would also point that's why this case is different than those cases that Mr. Wright cites in his client's response concerning attorney's fees. Those are cases where the adjuster had an IME in hand and then denied the claim. That's not the case here. IME report didn't exist at the time of the denial. It didn't come out until 5 weeks later. And like you said, there is no record in Mr. Cherney's claim notes or at his deposition that he had any indication as to what Dr. Kaplan's opinion was until long after this claim was denied.
All right. Very good. Let me hear Mr. Wright's response on how do I get to reasonableness by this adjuster minus Kaplan, or shouldn't I be minus Kaplan?
Yeah, I don't think it should be minus Kaplan. It was simply 5 weeks thereafter. But even if you were to say, just for the sake of argument, that
well, I mean, he denies first, and then later, presumably, is the first time he has a chance to see that.
Yes, Dr. Kaplan's report, and Dr. Kaplan's report, ironically, supported him. Couple things. First of all, with respect to there's other evidence here. For example, the EMS report, they said he suffered a cardiac arrest and no measures were taken to resuscitate him. The report also states that Ms. Grant stopped the cruise and stated Mr. Seals was not breathing. Before Mr. Seals was removed from the vehicle, it was confirmed that he was pulseless and not breathing. Ms. Grant also told the EMS personnel that Mr. Seals had been complaining of chest pain and some shortness of breath all day and was taking antacids and using his inhaler. She also told them that his condition was getting worse by the time they got on the highway. anyone knows, these are classic signs of someone that's about to have a heart attack. Now, when the report of Dr. Donahue supports that it was a heart attack, is in the autopsy authored by him, which indicates that Mr. Seals lost only 500 milliliters of blood. This is the equivalent of 1 pint and 1 ounce of blood. This is an amount that everyone gives at blood drives every day. And for him to say that 1 pint, 1 ounce of blood was sufficient for him
I have a
to,
sneaking suspicion that Mr. Seals would not have been eligible to donate for about 100 in different medical reasons.
right. But in either case, looking at it from a standpoint of Mr. Cherney, who is a layperson, and I've asked plaintiff's counsel to come forward with any evidence or any case law that says that he has to have any type of specific training or anything else to be a claims representative, and he does not. So based on what he's looking at, and he said that he Googled it, that it was 1 pint and 1 ounce of blood, the 500 milliliters. There are other indicators. The only organ that was damaged in the accident was, or allegedly it was damaged, was Mr. Seals' liver. There's no evidence of any bruising anywhere on his body. He did not have any broken bones, fractured skull, missing or broken teeth, other signs of external injury, save for some cuts and lacerations. In addition, his extensive pre-existing health problems, which included cancer of the left kidney. And by the way, Dr. Donahue comes up with that both kidneys weighed the exact same amount. But the problem with that is one of the kidneys, they removed half of it. So maybe it did happen that they weighed the exact. But anyways, Dr. Donahue said there was severe atherosclerosis with maximum stenosis as follows: left main artery, 50%, left anterior descending and left circumflex flex 70%, and right coronary artery 90 to 100%. And I'm not talking about Dr. Kaplan because that's what I'm trying to support it without Dr. Kaplan.
Well, I guess what I'm hearing is that you're saying your adjuster, me reading the facts in the light most favorable to you, had enough contradictory evidence here that he could, go against this, and unquestionably is a legal conclusion reached by the medical examiner that the cause of death is the impact, and say, I think the guy got it wrong. I think it was a heart attack, and to some extent going on a limb, if the internal guy had come back, Kaplan, or the internal guy, I'm sure he's not internal, but their expert come back and said, no, I agree with the ME, it was impact, then he would be hung out to dry, so to speak. But
Yes.
He's taking a shot and saying, I'm just a layperson here, but I do this for a living, and I think it was a heart attack.
Yes, and also plaintiff talks about the fact that Dr. Donahue said that it was the loss of the blood. The problem is that they don't know when the loss of the blood occurred. This is because Dr. Donahue testified that Mr. Seals could have bled from the liver lacerations after he died. So it's unknown whether the 1 pint and 1 ounce of blood or any amount of it occurred after Mr. Seals died.
We know he was entrapped, but I didn't see a lot of testimony about how he got out of the cab and stuff like that. I mean, presumably in there could have been some movement that caused, laceration on it. Boy, it would have to be pretty violent, it seems like, but yeah, I'm thinking of boxers that get punched in the lower regions and sometimes bleed like that, yeah, it has to be a pretty significant impact. So,
and if all the blood loss occurred after he died, then the blood loss could not be the reason for it. And
sure. And we'll never determine that likely, yes. Because right, we don't wear a blood meter.
The death certificate, which Dr. Donahue was supposedly the author of, cannot provide any assistance either as it did not have the actual or presumed time of death. It doesn't have either of those in there, so he doesn't know. And there's one other part of it. It's he could have said at the time of the as far as the time goes, impact. He didn't do that. It's empty. It's blank. So,
He
you know,
gives a date, but not a specific time.
right,
And that
right.
doesn't
And so-
necessarily render the certificate invalid, but it
Right.
certainly, we can presume he wasn't comfortable as to saying, here's the minute and time, or even within, an hour time when the guy died.
Yeah, and so it's something that the jury is able to look at and decide for itself, well, wait a minute, this thing's kind of questionable. You know, there's all kinds of questions here, especially like I said, with the EMS and just the report itself.
All right, Mr. Wesley, it's your motion. I'll give you the last word.
Thank you, Your Honor. I was waiting patiently. Remember the standard. So what the basis of the formal denial was at the time the denial was made. Everything Mr. Wright just talked to you about, Dr. Donahue's deposition testimony, which I disagree with how it's been spun here. That wasn't taken as of September 21st of 2023. Dr. Kaplan's report and opinions didn't exist at that time. And Mr. Cherney told us, I'm not making a medical determination. I am not engaging in medical decision making.
And inherently, when one decides that it was a heart attack and that he most likely died prior to, yeah, sounds like well, and I say a heart attack. I think the proper term would be a cardiac arrest. And as you point out, well, it's kind of a not exactly a precise term in medical terminology either.
Not a cause of it is not a cause of death or a manner of death. Everyone dies of cardiac arrest.
Someday we will all have a cardiac arrest.
We all will, unfortunately, Your Honor.
Yep. Well,
But so that's my point. Let's focus on what Mr. Cherney knew and based his decision on at the time he formally denied the claim. All this stuff that may or may not have took place after that is not relevant to the court's inquiry. Mr. Cherney doesn't get to change his testimony. Okay. We are where we are as of the date he denied the claim. And I think when you look at it, if you feel additional facts may be necessary to be developed during trial before you make a decision on the issue of attorney's fees, then then that is your right, Your Honor. I'm not going to tell you how to do your job.
and you're saying that I'm going to make that statutory determination of reasonableness. That's going to be for me anyways. That's
Yes.
not the sort of thing I could punt to the jury and say, hey, jurors, first of all, I want you to figure out, weigh the fact question and your call. Was he dead before he hit the tree and, lacerated, or was he, did that not occur until after the collision? And then second, folks, if you determine that, then I also want you to look at this issue of reasonableness of denial. That's not a jury question.
It may be if you decide to pass it to the jury. I believe based on the information that you have before you now, you can make that determination as a matter of law. If you feel additional factual development that is necessary to be presented at the time of trial, I believe that is a question then that would go to the jury.
Okay. Well, and as I said, looking at this case and just in looking at the argument that's been presented today, we have been talking about a lot of factual items, many of them frozen, as Mr. Wisely assiduously points out, in the form of testimony and depositions and things like that. It's not as if they may be fleshed out a little at trial, but they are, after all, facts that we can take, notice of today for the purpose of the motion. However, I do think, there is a classic question upon which reasonable minds could defer here if I take any of the evidence in the light most favorable to the defendant. That being that, it could certainly be presented to a jury at this point, and for now, if there's additional factual information brought out at trial, I'd expect, there may be a summary or directed verdict motion brought, at the close of plaintiff's proofs. But nonetheless, as the facts stand, I do believe that there is a fact question for the jury here. After all, the fact questions include, what indeed was the sequence of events here, timeline wise. It's undisputed this truck went off the road and at high rate of speed, 70 miles per hour, about thereabout, and hit a tree. And I think everyone's going to know that creates a significant impact inside the vehicle. However, there's also the dash cam video preceding that event, which shows clearly, as I think Mr. Wisely describes the driver there as in some sort of physiological distress, as indicated by his facial expressions. Is it a additional, issues that he attributes to digestion, or is he in the main, throes of a massive cardiac arrest? Well, again, the video shows us kind of an outward sign of that, and medical testimony might elucidate on that or expound upon that a little bit. And also important for this case is lay perception, in that a lay person, and I'll get to this a little bit when I talk about the adjuster, but a lay person is of course limited by not having the burden of all that medical training and saying, well, a cardiac arrest really doesn't happen until someone is pronounced dead on a slab and all cardiac activity has ceased, like we might see on one of the hospital Grey's Anatomy or something of that nature, but rather, and short of that, the person isn't in full arrest, and thus, why oftentimes we do see, heroic attempts by law enforcement and EMTs to bring the person back, as it were, by chest compressions and the paddles and things like that everyone's familiar with, that a person could be possibly revived, even if they're in the beginning stages of a heart attack or cardiac event. So, and all of that are inextricably fact questions that need to be determined by the jury. And likewise, the question of, well, was it reasonable to as the medical examiner questionably did here, attribute the cause of death not to a heart attack, but rather to blunt force trauma sustained after the accident. After all, this was a man who was in horrible health, by any objective observation, had, multiple comorbidities, probably, right, not the sort of person who necessarily, would have to bleed out, the full medically prescribed 2,000 milliliters to die, but rather any blood loss or, what might be a minor injury to another person, could have been a fatal injury to this individual. And those are inextricably going to be fact questions for presentation to the jury at trial. Second, on the determination of attorney's fees, the adjuster, and adjusters are, in the end of the day, lay people charged with the responsibilities of making a, for lack of a better term, a factual and financial conclusion on behalf of the insurance company that they work for. And here we had an individual who, confronted with a death certificate that said, boy, this guy died of blunt force trauma after a big accident, dug a little deeper into the medical report, presumably, and said, oh, I don't know, and also viewed the video. And I'll note, I had the opportunity to view the video. I didn't view it prior to this because one of the briefs had a series of stills that captured the expressions of the individual, and I felt like I was able to get a flavor through there that, he did look like he was in extreme discomfort prior to this accident, and no doubt that viewing the video would even reinforce that further. And as they sometimes say, a picture tells 1,000 words, and certainly in my experience, no more true than it is with a jury, and that the jury's going to come in there burdened, if it were, by perhaps incorrect perceptions of what medical things look like. But I guess looking in that video, one answer might be, well, hey, he shows every sign of a person, looks to me like I would think a person looks when he has a heart attack, even though admittedly, I've been fortunate in not seeing anyone in acute cardiac arrest firsthand. Of course, I've seen movies and shows and been to the first aid classes when people imitate it and things of that nature, and told all those signs that, again, were signs that he exhibited. So, and that's kind of further backed up by that EMT report, where the EMT is, again, not qualified to make the ultimate cause of death determination, whatever. However, make a determination, hey, this guy's so far gone from whatever, we're not going to try to revive him. We think it was a massive heart attack or cardiac arrest, and we'll put that down on our report. Again, creating a fact issue, but not dispositive in any different direction. So I am going to deny the motion at this time on both liability, the cause of death question and the attorney fee questions for presentation to the jury after the time of trial. I'll leave it to both counsel in pretrial motion practice and also during the trial to determine whether or not the reasonableness of denial is also something that could be placed in front of the jury, because certainly inherently, when I hear the question of reasonableness, I think, boy, that's a fact question. What would the ordinary person of the similar training do under those circumstances? So I'd be inclined to put it in front of the jury. However, I don't feel like it's necessary to rule as a final matter on that today. I'd hear additional arguments, but for today's purposes, we'll keep the entire matter open as a fact question to be presented at a jury trial.
Okay,
Just to confirm, basically denied without prejudice.
That is correct, Mr. Wright. Would you be so good as to submit me an order simply states for the
Yes.
reason stated on the record?
okay, I will do so.
Very good, gents. Nice briefing today. I greatly appreciate it. Gave me a real good picture of what the issues were here, and I appreciate the civility and wish you both happy holidays and safe travels if you're undertaking those. So
Thank you, Your Honor. You as
have
well.
a great one.
Thank you.
Thank you.